As we gradually exit from lockdown, businesses are seeking advice about the next steps that they should take. We know that businesses have had very different experiences over the past few months and are likely to be tackling priorities and concerns that are specific to their organisations. Many businesses will be eager to implement measures prevented during lockdown, to include reconstituting places of work in various ways and returning to standard operating hours. The lockdown restrictions may have had an impact on the business to the extent that difficult decisions have to be made about the future of the organisation and its employees. For some businesses, actions taken in response to the pandemic may have revealed new opportunities and different ways of working. Whatever a business's situation may be, it is crucial that employers consider the employment contract and connected processes when employees are returning to the workplace. Employers should take care that what is, and has been, agreed with employees is properly documented. And when applying variations to employment contracts, employers should review their policies and consult with staff.
Have you varied your employees' contracts as a result of lockdown? If so, it may be necessary to vary it again before that employee returns to work. Situations in which this may arise is if you've sent a letter to all your employees updating them following the introduction of the payroll co-funding scheme, and perhaps you've changed their hours or you've changed their pay. In such circumstances, it'll be necessary to consider whether that amounts to a variation of their contract, and if so, whether you then need to follow it up with further correspondence or documentation in order to either update or terminate the previous arrangement. We strongly recommend that you discuss any changes with your employees or indeed their representatives before changes are made to their contracts.
Employers that proceed on the basis of assumptions expose themselves to criticism, or claims even. Instead, it is important that employers have meaningful discussions with their employees to understand any barriers that might prevent employees from returning to their normal working arrangements. Concerns might relate to health issues, travel arrangements, or care for family members. A significant issue for many employees is likely to be caring for children who still have not returned to school. Employers will need to review how the business has dealt with this to date and consider how they might deal with this as a longer-term issue arising from the pandemic. Once the actual or perceived barriers are known, it will be necessary to consider them on a case-by-case basis. For example, can the employee start half an hour later so that they can drop their child off at an alternative childminder? Can they continue to work from home if they're considered high risk? Employers best placed to respond in the right way to individual needs are likely to be the ones that have a good sense of the wider workforce's ability to comply or not with the changes. A good holistic understanding could engender flexibility, creativity, and efficiency on the part of the employer to work through solutions to material challenges facing potentially isolated numbers of staff. The merits of surveying the scene from a human resourcing perspective risk being relegated or forgotten even in favour of pushing forward with the operational measures designed to quickly capitalise on the relaxation of the government measures. Such a survey needn't be protracted. If the right questions are asked, and if appropriate tools and processes at the employer's disposal are utilised, the employer could arrive at an informed view of its operational readiness quickly. Information gathered at this stage might be relevant beyond this next phase, and the exercise will likely be good for morale and mutual trust. Employers should be prepared to allow some time for employees to get their arrangements in place, and be prepared to be flexible if issues arise going forward. The needs of the business and the needs of the workforce may not be identical, and the two will only align by discussion and communication. Some of the outcomes may need contractual variations, others will not. However, all outcomes should be documented.
If the business is experiencing financial difficulties, the employer should be prepared to inform employees and discuss with them what actions might help the business to continue trading and retain staff. Employees are likely to understand the potential difficulties for the business at this time if changes are not made. If a business is considering reducing pay or hours, employees should be given as much notice as possible. The employer should explain why they are having to make the change and ask employees to confirm that they agree to the change. If agreed, the employer should confirm in writing the start date from which the variation will apply, how long the variation will apply for, the employee's new working hours for that period, and details of how the variation will affect their wages. Pay is a fundamental term in an employment contract and so can only be changed by agreement from both parties. If imposed unilaterally, the employer will risk claims for breach of contract, constructive unfair dismissal, and potentially redundancy. In the current circumstances, employees are less likely to object to a temporary pay reduction when the alternative could be redundancy.
If a business intends to amend employment contracts, particularly if they are considering reducing an existing contractual entitlement, a number of steps should be taken. Firstly, the employer should check to see if their contracts say that employment terms can be varied. If there is no variation clause covering the proposed change, the employer and employee would need to agree the change before the contracts can be amended. If there is a variation clause, the employer should check the wording to see what specifically can be changed in the contract. Employees may have to be given notice, or the employer may have to follow a specific process before making a change. Even if the contract allows the employer to vary terms of employment, it would be appropriate to discuss any plans with the employees or their representatives before deciding to make a change. The employer may need to enter into a full consultation process with employees depending on the exact nature of the change. If a change relates to anything that must legally be included in the employee's written terms of employment, the employer must notify the employee in writing. In both Jersey and Guernsey, that notice must be given no later than 4 weeks after the change.
If the business is looking to either remove or reduce the working hours from some members of staff and not from others, it will be necessary to ensure that the decisions are both fair and consistent, and that there's a clear business reason for treating the members of staff differently. Reasonable reasons will include the fact that they have different skills or that they work in different departments. We emphasise the need to have fairness, consistency, and clear business reasons because there's a real risk of discrimination claims, and furthermore, it's not very good for staff goodwill and it's not very good for their morale. If an employee is unwilling to agree to a reduced rate of pay or reduced hours, then the employer may need to consider their alternatives, such as redundancy or dismissal for some other substantial reason. It's important to highlight that the employer must follow the due process. Whilst tribunals might be more flexible in light of the current circumstances when considering whether the employer has followed the due process, there are no guarantees.
Consent would need to be obtained from employees in order to vary contracts in this way. Varying a contract to provide that it is temporarily a variable hours contract might be appropriate at this time if it isn't clear how many hours staff might be required in the workplace in the early weeks after release from lockdown. However, any variation letter should clarify that this is a temporary change to the existing contract. It is unlikely to be advisable to amend an existing contract to create a 0 hours contract. This would bring complications in terms of continuity of service and is likely to be of concern to employees, with the employer therefore less likely to obtain agreement. It would also mean that when the employer requires the employee to attend the workplace, the 0 hours employee would be under no obligation to accept any work. A variation to hours and/or pay is likely to be a more straightforward variation for employers to apply in the current climate.
In Guernsey, employers are not required by law to consider employee requests to change their hours, time or place of work. However, employees might wish to ask to vary their working patterns, perhaps permanently, to enable them to maintain a work-life balance that they have understandably become accustomed to while working from home. It's highly likely that businesses will see more requests for flexible working. Potentially declining such requests in the future may be rather difficult to justify. In March, most businesses were forced to significantly adapt their working arrangements at very short notice. Many have maintained their operations despite the restraints placed upon social economic activity having been lifted. Some have flourished. For many, working from home has been a positive experience over the past 2 months and has demonstrated that it can be productive for both employees and businesses. According to a recent survey, the Island Global research showed that 84% of residents in Jersey, Guernsey and the Isle of Man would be happy to work remotely more often after the pandemic subsides. 21% of those questioned said that they would like to work at home all of the time. 63% said that they would favour doing their job remotely at least some of the time, and only 16% said that they did not want to work from home at all. In Jersey, employers have a statutory right to request the change to their hours, time or location of work. The employer must follow a statutory process to consider and respond to that request. The UK government might introduce a new law giving employees the right to work from home as part of the government's new return to work package. No similar plans have been suggested in Guernsey or Jersey.
Jersey employers can refuse a request to change an employee's hours, time or location of work for specified business reasons. These include the burden of additional costs, a detrimental impact on business performance, or that the employer would be unable to meet customer demand. There have been no decisions in Jersey to date indicating how the tribunal will apply these rules. UK Employment Tribunal cases have demonstrated that if the employer handles a request in a reasonable and timely manner, it can reject an application for business reasons as long as the approach is not discriminatory. In 2015, in the case of Gleacher Shacklock, the employer was justified in refusing an employee's request to move from 5 days per week in the office to 3 days in the office and 1 day working at home, on the grounds that the arrangement would have a detrimental effect on the business in terms of the quality of service to clients and a disproportionate pressure on the small team. In a further case in 2015, the Employment Tribunal found that the employer was justified in refusing an employee's request to work from home, mainly in the evenings, on the grounds that the arrangement would be detrimental to the business due to the collaborative and short-notice nature of the work. A decided case in the UK Court of Appeal indicated that a blanket rule that all employees must work full-time is likely to be difficult to justify. If the Jersey Employment and Discrimination Tribunal considers that an employer did not adhere to the process for considering an employee's application to change their hours, time or location of work, it can order the employer to reconsider the application, and it can order compensation up to 4 weeks' pay.
Employers will now have the opportunity to consider a number of potential changes to their business, including how they use their office space and their technology solutions. Here are some bullet points to consider. Number 1, focus on the views and concerns of your employees and talk about the options. 2, consider a split or rotation between days or weeks in the office and days working at home. 3, make no assumptions and be mindful of discrimination. For example, don't assume that people with disabilities won't want to return to the workplace or that women will have childcare issues. 4, consider the impact of continued home working on the wider team, as well as training, assessment and performance review. 5, review your policies, including core hours and data protection. 6, if home working is to be a requirement rather than a choice, consider whether you will offer a financial subsidy for home working costs. 7, consider the options if staff are not able to work at home, for example, where young children are at home. And 8, consider the opportunities to attract a more diverse and inclusive workforce, whilst retaining existing skills and expertise, including carers, people with a disability or illness, and part-time staff. Subject to careful assessment of the potential challenges, there are clearly rewards to be had for both employers and employees.